on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This hearing takes a sharp turn almost immediately. Presiding over the case is Judge Urich, known for running a strict and orderly courtroom. The defendant, identified with sovereign citizen ties, faces 2 counts of public indecency after an incident in a local park. From the very beginning, it's difficult to tell whether his behavior stems from a deliberate attempt to appear unstable or from genuine confusion. What is clear, however, is that his approach follows the familiar pattern of resisting authority and refusing to engage with the case on legal terms. The result is a tense back and forth in which the judge works to maintain control while the defendant tries to derail the proceedings. It's an encounter that blurs the line between erratic behavior and strategy, leaving observers to question whether this is performance, belief, or something else entirely.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided of Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided of Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owned the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Hartwood Woods, which looks like it was deferred up as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000. Cash or surety, no 10% allowed at this time.
Judge Urich once again shows why he has a reputation for handling difficult cases with precision. Many judges facing sovereign citizen arguments either become visibly frustrated or allow the hearing to drag on far too long. Urich takes a different approach. He addresses contradictions directly, cuts off irrelevant points, and keeps the proceedings firmly on track. There's even a subtle touch of humor in the way he dismantles weak arguments, leaving no room for confusion about who controls the courtroom. The decision to set bond at $50,000 reflects the seriousness of the situation, with multiple felony charges already on the defendant's record and his young age. The court is signaling that releasing him back into the community without strong safeguards would be a risk. Whether his behavior stems from genuine mental health issues or is simply an act remains unclear. But either way, the consequences of his actions are catching up quickly. Judge Urich's firm stance underscores the balance between protecting due process and maintaining public safety.
If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with what is going on right now?
I'm sorry, sir?
I'm being told. I'm charged with this.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Did you guys catch that? He literally just told the judge, "We're about to go to war." I mean, come on, that has to be one of the wildest, dumbest things you could possibly say inside a courtroom. If I were the judge, I wouldn't have let that slide for a second. Straight to contempt. End of story. But now things get even more interesting. Because we're diving into his second hearing, and this time he's standing in front of a completely different judge. And let me tell you, this judge does not play around. Where the first judge showed some patience, this one has zero tolerance for sovereign citizen nonsense. The moment the theatrics start, you can see the temperature in the courtroom rise. And it doesn't take long before it gets heated. Honestly, I can't wait to hear what you all thought about that first hearing. Was it as ridiculous to you as it was to me? Drop your thoughts in the comments. Because now it's time to dive straight into hearing number 2. And, trust me, it only goes downhill for him from here.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Lynn Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
The living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think that given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
You guys think this judge is making the right call by putting the defendant through a competency review? Personally, I think it's the smart move. See, here's the thing: when a defendant tries to fire their lawyer, it creates a massive headache for the court. If the person is mentally incompetent, they can't represent themselves, and without an attorney, the whole trial falls apart. Now, this guy thinks he's some kind of genius. But let's be real, it's pretty obvious there's something not right? And when that happens, everything slows to a crawl. Worse yet, if the court pushes forward without making sure he understands what's going on, it could actually violate his right to a fair trial. And if that happens, boom, all the charges could get tossed. It's kind of like forcing someone to play chess when they don't even know how the pieces move. There's no strategy, no structure, just total chaos. Honestly, this review might be the only way to bring some order to this circus. Alright, let's get back to it.
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sunutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels, excuse me,
The evaluation.
what labels me incompetent? My intelligence because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I oversee the nature of the proceedings.
That you have the ability to assist your attorney in
And I would
defense.
want to withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
Almost certain this competency review is going to come back, showing this guy is mentally ill. Just look at his track record. He's stacked up felony after felony. And honestly, it doesn't look like he's slowing down anytime soon. Don't get me wrong, I believe in second chances, but this guy, he's burned through an entire deck of them already. Now, I can't quite tell if he's genuinely struggling with mental illness, or if this is just classic sovereign citizen nonsense, thinking they're somehow above the law. But, let's be real, getting caught messing with himself in public definitely tips the scale towards something's not right here. As far as the judges go, I think they handled it the right way. They stayed patient, they pushed back when needed, and they tried to keep things under control. Could a contempt charge have snapped him into reality? Maybe. But at the end of the day, I don't think anything short of treatment or a long stint behind bars is going to change this guy's behavior. But that's just my take. What do you guys think? Were the judges too lenient, or did they play it just right? Drop your thoughts in the comments, and if you enjoy breakdowns of cases like this, don't forget to like and subscribe for more. Thanks for watching, and take care.